At this time, I'd like to remind the parties and witnesses that issues of confidentiality are addressed in RSA Section 383.10 of the New Hampshire statutes, and specifically RSA 383.10b.
Explain that, please.
Yes. The statute and I'll give it, I'll just refer to the statute, and it's my understanding that we've got a motion that specifically raises this particular statute, but RSA 383.10b is as follows. I've got it here. Well, you got Mark. It's changed. It pertains to confidential information, and it's as follows. All records of investigations and reports of examinations by the banking department, including any duly authenticated copy or copies thereof in the possession of any institution under the supervision of the bank commissioner, shall be confidential communications, shall not be subject to subpoena, and shall not be made public unless, in the judgment of the commissioner, the ends of justice and the public advantage will be subserved by the publication thereof.
My intent is to go to a judge and allow to use this publicly.
Okay. The commission, would you like me to finish reading?
You don't have to.
Okay. So, before we begin the proceedings and before I have the department put on its evidence, I understand that there are two specific motions before us today. One is the motion to exclude testimony that the petitioner has filed and the respondents have objected to. The other is a motion to seal an exhibit. Why don't we address the first motion first? If I'd ask the department, because it's the
Should we disclose first and find out if there's conflicts right from the beginning before they start speaking about these situations?
I'd ask Attorney Wyant to just address that.
When
I'm
did
not
you do
sure.
that?
Excuse me?
When did you do that?
I haven't done it. I
Okay.
said I would ask Attorney Wyant to do that,
Thank you.
to address that. Although I'm not sure of the relevance of it.
Well, I can explain, and it's very relevant. I have multiple cases going on and cases with the Department of Justice in Washington right now. I've got witnesses with immunity right now. So it is extraordinarily relative. So I would ask you, what's the big deal?
Well, without answering that question, because I don't think I can, I'd like just Attorney Wyant to just address that.
Certainly. Well, first of all, since I'm not the adjudicator, I have no...
Could you speak up, please? I can't hear you.
Since I am not the adjudicator of this action, I have no requirement to be impartial. In fact, I am here representing the department, and therefore I'm not impartial in this action because the department initiated this action.
That doesn't sound like an answer, and it sounds like she's refusing to answer, which makes me think there's a conflict. Now, I'm just guessing. It wouldn't be with McLean Law Firm, would it?
You know, at this point, without getting into the rules of professional responsibility that lawyers operate under, I'm going to assume that the attorney representing the department today would disclose any conflicts that would prevent her to participate in these proceedings.
Then what would be the problem? She wouldn't know the conflicts unless she's said where she works, so I can determine and bring it to yourself to show you that it's a conflict. So why don't she tell us where she works, and I'll tell you if there's a conflict or not.
Well, first of all, Mr. Gill, it's not up to you to determine whether there's a conflict.
But it is by law if there is such a conflict. Now, if I do have these cases in and complaints in,
I know nothing about those.
well, I'm thinking this is why it's important to hear about it now. For instance, Richard Head from the AG's office, right, who's now in California, who I've got the banking notes and the corruption of FRM here.
I don't...
Well, wait a minute. See, this is where you don't understand the pertinence. The pertinence is that Head worked with Perlow from the McLean Law Firm. So I have that as evidence. What I'm telling you, I've been leveraged with bogus complaints for years. We have the bogus complaints, right? I have the meetings. It was Perlow who I informed the Ponzi scheme, FRM2, while he was at the AG's office. So see, it's very pertinent to this. So if she wouldn't mind, would she like to tell us where she worked prior to this so we have it as a conflict?
You know, with respect to that question, I'm going to not press her on this.
Not press her. This is a very simple thing. It's on an internet. It's her profile. Is it a secret?
You know, it doesn't matter.
It does
whether-
matter if there's a conflict.
For purposes of this proceeding today, and for purposes of the order to show cause that the department has
No,
set
but
forth,
I'm
and
saying
your
this is
responses to it.
direct relevance. Direct relevance. How about this? It's so direct she doesn't want to tell you. And she don't want to tell the camera.
Well, with respect to representation of past clients or other issues,
Is there such thing as conflicts? You're an attorney. Of course there is. This is a conflict. This is a conflict.
I don't.
You don't
haven't
know
seen any,
because you didn't
any-
ask her. Why don't we ask her? Maybe it's not. She could save us a lot of time, and she works for another law firm that isn't a conflict, right? I mean, there's a lot of other law firms. What's the chances?
Regardless of where she worked prior to her position at this point,
Well, I'm going to appeal right now because that isn't the case. It isn't the case. There is a conflict here. And you, as a hearing officer, should be asking her of that conflict.
I expect attorneys who appear before me, should they have any conflict of interest, not to participate in the proceedings and to bring that to my attention. That is generally.
I'm bringing it to your attention that there are conflicts and they're not disclosing it. So now it is brought to your attention. All you've got to do is ask the question.
If
Now, do you think about 5 minutes ago she would have said, this is where I work and there's no conflicts? If there wasn't a conflict, do you think we'd be hearing that? Of course there is. This is a cover-up. This is leverage. This is about notes that are 12 years old that they tried at the same time. Richard Head from the AG's office, who worked at McLean, put this in at the same time the Banking Commission put it in as a complaint. So let's take a look at this. In 12 years, they
Mr.
land
Gill.
on the same nest from McLean.
Mr. Gill, at this point in time, I would like the parties to address the motions that I just referred to, and then I'd like to move the hearing forward.
Isn't it my legal right to know if there's conflicts going into a hearing?
Well, to the extent that any conflicts might exist, or
Yes,
might
it
have
is my
exist,
legal right. Isn't it?
It's up to the attorneys coming in before me to.
Disagree. It is
Okay.
my legal
You
right.
You can respectfully disagree with me on that.
I'm
That's
not.
fine.
I'm saying you could ask the question and you're not.
I'm happy to.
Now, how about that? If she works for McLean Law Firm and Richard Head,
I don't know where she worked
well, I've
before.
got under
I don't-
oath, I have a complaint with the Department of Justice, which is this tape is going to right after we're done. So do you want to say you don't want to ask the question? Because you may wind up asking questions, getting questions yourself.
That's, regardless of that, what I'd like to do is move
Okay.
forward on this.
All right?
And
But we are going to be in front of a judge shortly with this.
I'm going to ask Attorney Wyan a question. Attorney Wyan, do you believe you have any conflicts with respect to your participation as an attorney for the New Hampshire Banking Department?
I do not.
Thank you.
Well, you didn't ask her where she worked for. And what's the problem? Is
I don't
she
need
ashamed
that.
where she worked before? I'm telling you, it is a conflict. I don't know where she worked, but I'm guaranteeing you it's one of those law firms.
Duly noted. Duly
I
noted.
also
and
wanna-
You can make note of that. I would like to proceed with the hearing. So the first motion I would like to address is the motion to exclude witnesses.
It's for those reasons that the department moves to exclude the testimony of Commissioner Perlow, Attorney Walker, and Attorney Friedman.
Second.
Yes.
Mr. Gill?
Well, what the Banking Commission's trying to do is cover up what they really asked for and wanted and I have right here, is the notes reclassification. Whether it's not their responsibility or doing it, so you think about this. The DRA, Richard Head, on the same week files a complaint into court. So does the Banking Commission to change the classification of the notes, which was illegal. So at the same time, so Mr. Furlow working for the AG's office with Richard Head, we know each other, both worked in McLean Law Firm and set this up exactly, which is why the Banking Commission doesn't want to get into that. They don't want to talk about that. But yet they talk to my controller, they talk to my compliance officer about this and try to get them reclassified. This is exactly a plant, an attempt to try to classify it to get the AG's office out of trouble. So that's what it is, which is why we don't know where she worked. But we'll find out. Now, they're saying it's not involved with these people. I'm saying it is the notes. So each and every person here is directly responsible. Well, let's start. Let's go with Banking Commissioner.
May I stop you for a second? What do you mean by the notes?
There was notes that the company had given me to invest in another business. Ready?
These are financial instruments.
Right. 2003. Well, the notes from the IRS was classified as business. So it doesn't go on the K-1. They're trying to get them reclassified. Only 12 years later, as the AG head that is connected to Furlow. So it is connected. They're trying to cover up the Ponzi scheme of FRM with Furlow, who works for the AG's office. Always has. Now you ready? I met with Mr. Furlow, spoke to him about FRM, and I have multiple false complaints.
Okay.
Well, no, not okay, because this is pertinent. So these complaints, right, were bogus. His own admission. For instance, Friedman, I'm asking, he was in a meeting with me in a Banking Commission Furlow where he said, sue us. In fact, Friedman, inside a deposition, said it was the worst corruption he's ever seen in 30 years. Now, I have that. Now, Mr. Friedman was with me, and the discussion of the notes had previous was, so there. Walker also had been my lawyer and had worked with this and had discussions already with the notes 10 years before. So they're all applicable to right now.
Okay, Mr. Gill?
Well, wait a minute. I haven't even gone.
Well,
So I need, what I'm asking for, I need these witnesses. I am not getting a fair hearing if these witnesses aren't being called.
The department has stated that TMS is licensed and has been as a mortgage banker pursuant to the provisions of RSA 397-A. And the order to show cause, as I read it, specifically alleges, and it's your burden to demonstrate that it is wrong, that
Well, I am trying to do that. We're not allowed for witnesses. Are you trying to tell me I can't have any witnesses, sir? Now, I just told you where it's extraordinarily pertinent. You may want to read this if you haven't already. So you'll know that this is very pertinent.
is that a document that you're going to put into evidence?
I'll put it in the evidence.
Well, you'll have time to do that. I'm getting to the crux of both the order to show cause, as I read it, as it has been presented, and the department's motion to exclude the testimony of 3 witnesses. Those particular witnesses, we've been told, their presence can't tend to prove or disprove.
Who told you? They did. That's not a hearing. I'm making an argument that it does, clearly.
The issues associated with the order to show cause, which, as I read it, are failure to facilitate, the lack of an information security program, the lack of an anti-money laundering program, and the order to show cause states that
These are based on harassment pieces.
there are particular statutes that require these, in this case, 3 components.
I'm comfortable with going to court and arguing those issues. No problem. But
Okay.
I am not getting a fair hearing if these
This
are
hearing
all
is
stems.
only related to the order to show cause.
Well, it can't be, because it is related. First of all,
Well, it is-
we're not even, we've taken the conflicts and disregarded them completely, and then you're turning around and telling me I can't have any witnesses to exactly what they referred to. How's that for a kangaroo
I haven't even,
court?
no, I haven't even said that.
Well-
I've asked you to respond to their motion.
I did respond, and I
are
told you
you
these
finished?
witnesses
Are
are
you-
extraordinarily pertinent to my case.
To your case.
Not this case right here.
Well,
for instance, the timeliness. Maybe you should see a video where I have, because then it does speak to the nature of what they're doing. And it does speak that I have 3 outstanding bogus complaints for $1 million. You want to tell me where they went before we talk about this? Do you know where they went?
Do you have anything else to add about your,
Well, we
presumably your
have the
objection to the
complaints.
motion to exclude?
Right, Mr. Friedman could come in here and tell you this, as he has with the Department of Justice in Washington. So let's bring Mr. Friedman in, because I think this is very important. That's what this is, and I'm not going to get a fair hearing otherwise. They're not discussing the conflicts and no witnesses to exactly the issues that they bring up. So Mr. Friedman, be a very pertinent witness to this. For instance, we have a video now. Do you know what they asked me on timeliness? I had 3
Do you,
boxes of paper, the length of a football field and a half. That's what they required me for. They couldn't find me a penny, except for I was late with the information.
I admit, at this point in time, I think I've given you enough time to respond to their motion. I'm going to grant the department's motion to exclude the testimony of those 3 witnesses. I haven't heard anything from you as to
I did give you
responsive,
something.
that is responsive to their objection.
I did give responsive is that this was it was a leverage piece. That listen, the banking commission has offered me releases. Did you know that?
I have no, I
Well,
don't know
listen,
anything
I'm
about
informing this court that they have, right?
that. I don't know anything
And all
about
I have to
that.
do is not say anything. So I hope you get that.
At this point in time, do you have anything more to,
Yes, I believe that this is a rigged court. Have you done, Mr. Ellis, multiple cases for the Banking Commission? Would you
I-
like to disclose how many have you done?
I'm an appointed hearings officer under statute.
Who appoints you?
I'm appointed by and delegated by the commissioner of the banking department.
Mr. Perlow?
Yes.
Oh, well, Mr. Perlow is giving you a job, and Mr. Perlow is involved in this, right? So in other words, this is exactly looking like what it is.
Okay.
Could you?
Let's move on.
I object.
Okay?
I
The
object to
objection
this
is duly
hearing,
noted.
moving forward, not be in front of a judge. I am not getting a fair hearing here. And I believe that you are getting paid by Mr. Perlow from the Banking Commission as, in effect, as the commission. You are not allowing me witnesses or to have the Banking Commission declare any conflicts, which I'm certain that there are. And now you're going to incriminate yourself, because this goes right to the Department of Justice.
Okay. You have the right to pursue any remedies you want to or
And you don't have
outside
the
of
right to
court.
break the law. And you're breaking the law right now.
I'm going to grant the department's motion to exclude 3 witnesses. And I'd like to address the next motion, which is the motion to seal Exhibit A that the department has filed.
I disagree with sealing any of this. This is going to be all made public.
And I would like the department to address that at this time.
Certainly. The motion to seal is based in part on the confidentiality provision that you read for the respondent earlier, RSA 383-10-B, which states that all records of the department's and all reports of the department's examination shall be confidential and not subject to subpoena. In addition to the general provision of confidentiality for the banking department, RSA 397A pertains directly to mortgage bankers and brokers, and RSA 397A:12 specifically deems reports of examinations of non-depository mortgage bankers and brokers to be confidential and not subject to public inspection. Specifically, it states that all reports pursuant to this section shall be absolutely privileged and shall not be subject to public inspection. It goes on to beyond the report itself. It provides that the comments and recommendations of the examiner shall also be deemed confidential information and shall not be available for public inspection. So therefore, and this exhibit, or not exhibit, this motion to seal pertains to Respondent's Exhibit A, which is the report of examination from the most recent 2015 examination. And it's on the basis of the requirements by law that the department moves to mark the exhibit as confidential and to seal that exhibit.
Attorney Wyant, if, assuming that the respondents have introduced Exhibit A as a witness, or as evidence, or actually wish to introduce it, would your motion to seal prevent them from doing that?
To present it as evidence?
As evidence in the hearing.
No, actually, I was going to actually make another motion. It wasn't something filed because this pertained just to the exhibit. But to the extent that there's testimony obtained around that exhibit, the department would move to close the hearing at that point because because that would pertain directly to the confidential report of examination.
All right, but the hearing would go forward, but just with the parties involved. Is that what you're saying?
It would be just the parties. During testimony around a confidential exhibit, the hearing would need to be closed except for the parties. It would require that any recording equipment other than the record itself be turned off, however.
Okay. Do you have a response to the
Well, I
department's
object to
motion?
that. What it is a cover-up, a sealing order. That's exactly what they do when they want to cover up. So let me understand this. You can't have any witnesses. We're not going to tell you the conflicts, and you can't tell anybody. Well, I object on the basis that it is corrupt so that I can, and I will.
Do you understand that, the way I understand it, is that the department would certainly, you'd be able to present Exhibit A before me today in your case.
I'm saying
and-
I understand what you're saying, but this is for the public and the protection of the public, and they're supposed to represent the public, so it's going to the public. And it is a sealing order on this, the sealing order on this, so I don't turn around and show everybody what they're doing. So I object strenuously to the sealing order. No witnesses, conflicts, and a sealing order. Listen, I've been here before. This is a setup from the beginning. I mean, this is obvious.
Well, I'm going to reiterate that during the hearing, under RSA 383:10B, that particular confidential information would be accessible to you during the hearing, and it could be presented to me.
I'm talking about the public.
With respect to the statute, I am not going to determine whether indeed this is under the
So you're not going to
public.
make a ruling if I can go public or not? Is that what you're saying?
I am not going to make a ruling
Wow.
because
Why is that?
I don't have the authority to do that
Well, you had the authority to hear the case. What makes you not have the authority on this?
because I've been delegated the authority to hear this case. I have not been delegated the authority to make
So
decisions
you're
regarding
not
the.
equipped to make a decision
Not-
here. This decision is needed to be made here. So
You-
you're saying you
can
can't make a
proceed-
decision.
You may proceed introducing that into evidence after I close the hearing and put
I
the
don't
exhibit
think
under
that you
seal.
should be on this case. I think
So-
you should recuse yourself.
I'm going to, have you completed your objection to the department's motion?
No, go ahead. You rule for them again. on camera.
I'm going to grant the department's motion to seal Exhibit A at this time. And now I'd ask the department to
But wait a
present their
minute, you just
case.
said you couldn't make a ruling. Now you just made a ruling.
I can grant the objection, I
Well,
can
wait a
grant the
minute,
motion to
Did you just
seal.
say you couldn't make a ruling on this? Did you just say that?
No, I didn't say that.
Could you? You didn't say that? You didn't say you couldn't make a ruling.
As a hearings officer, I've been delegated specific authorities.
So, I mean, who told
Authority.
you that? Who told you? Is Mr.
I've been
Perlow tell you
delegated
what to say?
authorities by the bank commissioner.
Oh, Mr. Perlow.
He is
Right?
the bank commissioner.
Is it Mr. Perlow you were talking to?
And I've been delegated authority by the bank commissioner.
Who is
and-
who?
It's part, Commissioner Perlow is
Oh,
the
so
bank
you
commissioner.
can say Perlow.
I certainly can.
Good, for the camera.
The issue is, I have not been delegated authority to make determinations of whether in the public interest confidential information can be distributed or made public.
Well, then, what,
And
but I'm telling you,
Attorney Wine?
the conflict is for the public.
The department actually would also say that, given the way that the legislature drafted RSA 397A, it actually, with respect to non-depository institutions that we're dealing with, that the legislature in that area did not leave any discretion to make something public.
thank you. So I'm going to grant the department's motion to seal.
Of course you are.
And you're certainly welcome to use that exhibit during the
Well, I'm
hearing.
going to report you to the Department of Justice with this. Don't worry, we get it all on camera. Keep going.
Would the department like to proceed with its case?
Yes. Please turn to Exhibit 4. And I know there's a lot of black on there, so we can talk about that in a second. Can you tell us what we're looking at here?
This would be the kind of the cover page response of the document request list.
Excuse me, object. Where is this page that we're referring to that's completely redacted?
I just said we will explain the redaction in just a moment.
Well, how can you explain a redaction that we can't see? I mean, there's a lot of redactions through this whole thing, though, isn't there? Now, why is there so many redactions? Can I ask the hearing on that? Why do we have all these redactions?
We will find out.
Well, it's a cover-up is what it is. And where they came at, that's why it's redaction. Hey, listen, if it's all sealed, why redact, right?
Well,
Proceed with your questioning, please.
who provided, where did this document come from?
Well, wait a minute, object again. Is this the document?
Is that
It's not a
Exhibit 4?
document. Is it?
It is a document.
This is a document.
Yes, it is.
Completely
It's a-
redacted. This is a document that we're going to refer to as evidence, right? Then if we are, then I don't think anything should be redacted.
It's a document that the department is seeking to place into
Oh, I
evidence.
can't use it as evidence in this hearing, and they're even referring to it. A black page.
It's up to them to demonstrate and say, explain
Well, isn't it
for
up-
me what it is.
Well,
So
how
please
can you
proceed.
explain what it is if it's redacted?
Please
How about
proceed.
we start by saying this?
Mr. Gill,
Why is it redacted?
please proceed. Attorney
We're
Wyatt,
testifying on evidence that's on a black page.
the attorney just stated that she would
What, tell us what it says?
have the witness testify
Well, I
as to
don't
that.
trust it.
Well, I want to hear it as well as you do, so why don't
Well,
we
I don't want
continue?
to hear it. I want to see it as they're prescribing it as evidence today.
All right.
We're putting
Duly
in
noted. Thank
evidence
you.
that is a black piece of paper that's completely redacted. And can we have, how about this? Does this seem fair to you?
I would like her to proceed with the question.
Could we have
And then
this
when you have-
unredacted so
when you
she
have-
can read it and I can read it at the same time? Does that seem fair?
At this moment, I would like the department to continue its questioning.
Wait a minute.
Thank you.
Do we
No,
have
thank you.
this
Please
page
continue.
non-redacted?
Please continue.
We're asking
The
for...
department.
Thank you.
The department has, I can offer the reason this is redacted is to enable this to be a public document. The portions that pertain to the issues in the order to show cause are not redacted, as you will see when Ms. Cloutier continues her testimony.
Can we read that page then? Can
The
we see
department-
that evidence?
if this
The
needs to come
department is
in-
explaining that they are covering up and they're giving evidence on redacted paper.
Ms.
That says
Cloutier-
nothing.
Thank
Then
you.
how about, I
Thank
mean,
you. I
Ms.
think you
Cloutier,
made your
can you-
point. I
No,
understand
no.
your point. I'm going to ask the department to proceed. I would also ask you to be respectful to me and to the tribunal. At this point in time, I would like to hear the department move along. You will be offered the opportunity to ask questions.
well, you do aware I am filing a complaint with the Department of Justice. I mean, this is, we're testifying on black paper.
Please proceed.